1956 rules.
Why? Now, if we turn to clause 1 of Article 268, and if I may reread it.
Before going to that, if you read Article 75, please read that. That is, I think it is relevant. And specifically sub-article 3. Yeah, what is law? It has been defined.
Law को कह रहा है कि जब वो act
पार्लियामेंट पढ़ लेगा
जी मैं उस मैं आ जाऊंगा
under sub-article 3 it is still when the president has assented to it is deemed to a bill, it shall become law and be called an act of
Parliament. Yes.
So if it is assented by president, the law is an act of the parliament.
मैं सिर्फ ये तो मैं ऐसी एट द आउटसेट में बता चुका हूँ. मैं इस वक्त उस क्वेश्चन को एड्रेस कर रहा हूँ जो ये आया था कि जी एग्जिस्टिंग लॉ, बिकॉज 56 के रूल्स एग्जिस्टिंग लॉ हैं एंड 191 के नीचे वो लॉ की उसमें आ जाएंगे, एंड देयरफॉर जो हमने सुप्रीम कोर्ट ने रूल्स बनाए हैं they are perfectly all right. They could only be.
Mr. Attorney General, if I have understood you correctly, you say the term law used in Article 191 does not include the 1956 rules.
And not include 1956 rules as existing law.
No, but my question to you is, are the Supreme Court rules 1980 currently framed, are they law?
No, not within the meaning of 191. No, not within the meaning of 191. And let me please try to explain it.
I am saying
इसको explain कर लेने दें ताकि at least वो question address हो जाए.
Neighbor, one word answer is no, they are not law.
They are not. They cannot be treated as.
Obviously, they are not law within the meaning of 191 because otherwise the argument is circular. How can this?
Yes, I mean, yes, my lord is right. My lord can complete what he is saying. Yes, that's right.
Leaving that aside, I'm still curious. Are the rules, forget 190, the use of word law in 191. My question is more general. Are the Supreme Court rules 1980 law or not?
The Supreme Court rules 1980 regulating practice and procedure cannot be called law within the meaning of 191. So
but isn't it law under the Constitution? Under the Constitution, say says na by or under the Constitution. This is something mandated under the Constitution. It derives its.
Are your rules of Are your rules of business made under Article 99? Are they law?
मुझे एक चीज.
हाँ मुझे बताइए.
मुझे एक चीज.
अरे Attorney General साहब.
एक चीज जरा मुझे एड्रेस कर लेने दें.
Extraordinary statement which are the rules of business made under Article 99 law or not?
My lord, my submission is that in the broader sense, in a broader sense, yes, they would be, they would have the meaning of law for the purposes of regulating the business of federal government. Yes.
Are the rules of the National Assembly rules of procedure made under Article 60?
Yes. My answer to your question was that for the purposes of 191, they cannot be called.
But that was not my question.
Generally speaking, yes.
Vakil Sahab, that was not my question.
Sir, मैंने कहा generally speaking, yes.
Generally speaking नहीं, एक but generic question आपसे.
मैं अभी तो एड्रेस कर रहा हूँ और चीज. अभी एड्रेस ही और चीज कर रहा हूँ. अब आप उसको
Constitution ने law rule making power दी है executive को भी, legislature को भी, Supreme Court को.
Absolutely.
सवाल ये है जो executive ने अपने rules of business बनाए हैं in exercise of powers under the Constitution, are they law?
Yes.
Yes.
Yes, they are law.
जो लेजिस्लेचर ने अपने रूल्स ऑफ बिजनेस बनाए हैं, आर दे लॉ? इफ दे आर लॉ, देन व्हाई आर द rules of business, rules of procedure framed by the Supreme Court in exercise of powers granted by the Constitution, the same powers which the legislature has, the same powers which has the executive has, not law.
इसी को मैं एड्रेस करना चाह रहा हूँ.
जी करें.
आपने कहा कि जो हमारे रूल्स थे 1956 के,
56 को जो 80 की बात कर,
उसको नहीं, उसको अगर हम एक तरफ रख दें, at least we can address, we can take care of, and I need not make any further submissions on them being existing law and thus the term law including those meaning those 1956 rules. If that is accepted, I need not make any submissions.
I'm not accepting. What I'm saying is, आप 80 के rules की बात करें, वो law हैं या नहीं है?
मुझे आप पहले वो एड्रेस तो करने दें. अब आप उसको एक्सेप्ट नहीं कर रहे, मुझे सबमिशन उस पे कंप्लीट तो करने दें.
If I've understood you correctly, you say 1980 के जो rules हैं वो under the term law आते हैं. However, in the context of 191, you cannot consider them as law, because then the entire process, then there will be contradiction within the letter of Article 181.
Absolutely, my lord. And यही contradiction है जो उस argument में है या उस point में है कि जी वो because existing laws में आते थे.
वकील साहब एक जरा kindly Attorney General sir, you're making, speaking for myself, an extraordinary submission, so I want to be sure I understand it. Now, you say 1956 rules are not existing law, but you say that the Supreme Court rules of 1980 are law in the broader sense of the term. Right?
Please rephrase me. Let me rephrase myself. What I said was that they would be existing laws. They would be existing laws covered under 268(7), but they cannot be termed or treated as law within the meaning of term law used in 191. That's what I'm saying.
मैं समझ गया हूँ बात, but still I'm. The reason I'm asking this question is that Rule 1, Sub-Rule 2 of the Supreme Court rules, which you say is law, specifically says the Supreme Court rules 1956 are hereby revoked.
Yes.
So both have to be law. Both have to be law. Otherwise, in 1980, the Supreme Court could have said there are no laws. There is the Supreme Court rules of 1956 never existed. They ceased to exist when this Constitution came into being. We don't need to revoke them.
So what this means is, मैं आपकी बात तो समझ गया हूँ, बेटा
नहीं, आप मेरी सबमिशन तो जो आप फरमा रहे हैं मैं उसको समझने की कोशिश कर रहा हूँ.
मैं ये कह रहा हूँ,
अरे बात तो सुन लेना. आपने जो आर्टिकल 268 पढ़ा, क्लॉज 1 पढ़ा, that says subject to Constitution. And so it is possible, is it not, that the 1956 rules were existing law.
Yes.
But the power to amend existing law within the meaning of clause 1, article 268 was subject to the Constitution. The rules of 1956 were the rules that applied in terms of the rule-making power, not law, rule-making power of article 191, and therefore the same shouldn't say problem, issue I would say, in relation to any legislation affecting, amending, restricting, repealing, whatever, the 1956 rules applied as it does now in the context of this proposition before us, this act versus the 1980 rules, exactly the same position applied. Would you agree with that?
Yes. Yes.
Yes.
Yes.
Thank you.
And that is why I would just conclude by this submission by saying that when existing laws
जो पूरा अपना बहस आपने जो पूरी अपनी बहस शुरू की है वो आपने किसी और बेसिस पे शुरू किया. आप अपने आर्गुमेंट्स करते तो ये सारे मसले आप लिए खड़े नहीं होते. So sometimes it is not very easy to give a yes/no answer. It was like the young, on a lighter note, माहौल भी जरा ठंडा रखते हैं. On a lighter note, a lawyer was battering a lady during cross-examination. The husband representing the lady, and he said, "Have you stopped beating your wife? Answer yes or no." So, keep it things light and move ahead.
So I'll just conclude my this submission by saying that the 1980 rules or the 1956 rules, though they were existing laws when the Constitution came in, but saying that they were the law within the meaning of Article 191 would be a contradiction.
Okay, can I ask a question?
आगे चलता हूँ.
ये एक सवाल सुन लें कि आप ये कह रहे हैं कि वैसे तो the rules are law, but for the purposes of 191 they are not law. Now wherever the word law has been used, what principle of interpretation will be applied to see whether these rules or any other rules will be applicable there in the term law or not? The reason I ask this question is that the first day, my question to you was that if subject to the constitution and the law meant law just an act of parliament to the exclusion of everything else, then maybe the word law was not the right word. So when we look at the word law, we have to read something more than just an act of parliament. So the act of parliament is there, but other things are there. Now you are saying उसमें से आप ये rules निकाल लें because यहाँ rules नहीं apply होंगे, then in some other provision rules डाल दें because वहाँ rules apply होंगे. So there doesn't appear to be any principle of law that one is following on the basis of which one would determine where to use what part of law.
ये इसमें learned attorney general